On a cold Thursday morning in January, a widow named Clara Beiler walked into Courtroom 3 carrying a brown grocery envelope. The bank had brought 2 attorneys. Clara brought 1 sheet of paper. That was the imbalance everyone could see. What nobody could see was that the sheet of paper had been waiting inside her husband's roll-top desk for 52 years. By 10:17 that morning, the attorney for Millstone Valley Bank was telling Judge Ruth Kessler why Clara's dairy farm should be surrendered within 60 days. The loan was valid. The default was documented here. 280 acres outside Quarryville, Pennsylvania, all pledged against a $486,000 agricultural note her husband had signed 3 winters earlier. Clara was not on the note. Her husband, Isaac, had died in September. The bank's first default letter arrived 9 days after the funeral. Clara sat at the defense table in a gray coat with 1 missing button, listening to the bank describe the place where she had raised 4 children as an asset scheduled for recovery. Then the judge turned to her. "Mrs. Beiler, do you have anything you wish the court to consider?" Clara stood. Her hands were shaking badly enough that the envelope made a small scraping sound against the table. She said, "Your Honor, I was told to give you this before anyone signs anything." The bailiff carried the envelope to the bench. Judge Kessler opened it, pulled out a folded deed dated October 3rd, 1971, and began to read. She read the first paragraph. Then she stopped. She looked at the bank's attorney. Then she looked back at the page. For nearly 5 minutes, nobody in the courtroom moved. When the judge finally set the deed down, she removed her glasses and said, "Counsel, I am calling a recess." The bank had entered the courtroom expecting a foreclosure. It had just been shown a fence. Not a fence of wood or wire. A fence built into a deed by a farmer who had been dead since 1986. And it had held. The Beiler farm sat on a long slope of limestone soil 3 miles south of Quarryville. From the road, it looked ordinary. A white farmhouse, 2 bank barns, 1 silage tower, weathered pasture rails, and a narrow lane that curved through maple trees before reaching the dairy parlor. But the land had never been ordinary to the Beilers. Clara's husband had inherited it from his father in 1998. His father had received it from his own father, Amos Beiler, in 1971. Amos had bought the original tract after World War II with savings from a feed route and a team of Belgian horses he refused to sell even after tractors became common. Amos had lived through the Depression as a boy. He remembered farms being lost over signatures men barely understood. He remembered neighbors packing dishes into crates while bank agents measured cornfields in their church clothes. So when Amos transferred the farm to his son, he did something his family remembered only as a vague saying. He used to tap the farm desk and tell his children, "The fence is in here." They thought he meant the records. They thought he meant discipline. They thought he meant faith. He meant a clause. In 1971, Amos paid a Lancaster attorney $38 to draft a deed with a lineal re-entry reservation. The name sounded dry. The effect was not dry at all. The clause said that as long as the farm remained in Beiler family ownership and was being actively farmed by a direct descendant, no creditor, lender, lien holder, or outside party could force the land out of the bloodline. Any attempted forced transfer would trigger an immediate re-entry of title to the family line, leaving the creditor with a debt claim, but no farm to seize. It was old language. It was unfashionable language. By modern banking standards, it was almost invisible. But it had been recorded with the county on October 11, 1971, stamped into the public chain of title, and never removed. For 52 years, the clause waited under ordinary paper. Milk receipts, seed invoices, veterinary bills, tax returns tied with twine. The bank did not find it in 2020. Isaac Beiler did not know to look for it. Clara found it because grief gives a person strange endurance. After Isaac died, she stopped sleeping through the night. Around 3 each morning, she would sit in his office and sort the farm into piles. Keep, pay, ask Roland, burn later. The room smelled like dust, leather, and the peppermint drops Isaac kept in the top drawer. On the 19th night, she opened the bottom compartment of the roll-top desk and found a narrow drawer behind a warped wooden panel. Inside was a grocery envelope with 3 words written in Amos Beiler's careful hand. Do not discard. Clara almost put it with the old papers. Then a second line caught her eye. Farm transfer original. She unfolded the deed at the kitchen table under a yellow lamp, reading slowly because the language felt older than the house. She understood the names. She understood the acres. She understood the signatures. She did not understand the clause. But she understood one phrase well enough to stop breathing for a moment. No forced conveyance shall defeat the family's right of re-entry. The next morning, she took the deed to a retired title examiner named Walter Neff, who worked 2 afternoons a week behind the counter of the county historical office. Walter read it once, then put both hands flat on the desk. "Where did you get this?" "My husband's drawer." "Has the bank seen it?" "I don't think so." Walter made 3 phone calls before noon. Tuesday evening, the deed had been reviewed by Walter, a farm law attorney in Lancaster, the county recorder's deputy, and a retired orphans court clerk who had handled agricultural estates for 30 years. They did not agree on how the bank would react. They agreed on one thing. Clara had to get the document in front of a judge before the foreclosure order was signed. That was why she walked into court with a grocery envelope, while the bank walked in with binders. Millstone Valley Bank had not behaved like a villain. That made the story harder, and in some ways worse. Its loan officer, Terrence Morrow, had known Isaac for 15 years. He had attended the same livestock sales. Isaac's hand outside the feed mill. When Isaac wanted to modernize the parlor and buy the adjoining 40 acres from a neighbor's estate, Terence encouraged him. The old setup was still working, but it was tiring Isaac out. The new setup promised fewer hired hands, cleaner milk lines, and enough scale to keep the farm viable for the next generation. The problem was that the next generation was uncertain. One daughter taught school in Harrisburg. One son repaired diesel engines near York. Another daughter was married in Ohio. The youngest, Daniel, still helped with hay and evening milking, but he had a job installing well pumps and the young family of his own. Isaac signed the note anyway. The principal was $430,000. The bank secured the entire farm. The title search came back clear. Or it looked clear. The commercial title company found the recorded deed, confirmed the acreage, traced the transfers, and missed the reservation on page 4 because it did not look like the liens and easements their checklist was built to catch. Then milk prices softened. Feed costs climbed. The new parlor saved labor, but it did not create the extra cash Isaac had been promised on paper. By the summer before his death, he was paying interest more faithfully than principal. Clara knew things were tight, but Isaac had always carried worry privately. In the plain farming world where he had been raised, a husband did not bring bank fear to the breakfast table unless the barn was already on fire. The barn was not on fire. The loan was. When Isaac collapsed beside the calf pens on a September afternoon, Clara thought she had lost a husband and kept a farm. By October, she understood she might lose both. The bank's attorneys moved quickly because the paperwork told them they could. The note was signed. The default was real. Clara had no income strong enough to refinance. The estate had machinery and cattle, but not enough liquid value to cure the arrears. The bank petitioned for foreclosure. The hearing was supposed to be routine. It remained routine for 24 minutes. The bank's attorney, Nathaniel Price, explained the note. He explained the missed payments. He explained the title policy. He explained that Clara was not being personally sued, but the farm itself was pledged collateral. Judge Kessler listened with the weary attention of someone who had heard clean paperwork produce ugly outcomes before. Then Clara handed her the deed. The courtroom changed before anyone understood why. During the recess, Nathaniel Price stepped into the hallway with his phone pressed to his ear. He called the bank's outside counsel in Philadelphia and read the operative language from the 1971 deed. The partner on the other end interrupted him twice. "Read that sentence again." Nathaniel read it again. There was a long silence. Then the partner said, "Is it recorded?" "Yes." "In the chain?" "Yes." "Is a direct descendant farming the land?" "The youngest son helps run the dairy. The widow still operates under the estate." "Then you do not ask that judge to rule against you." Nathaniel lowered his voice. "What am I asking for?" "You withdraw the foreclosure petition immediately. You reserve the bank's claim against the estate assets if necessary. You do not pursue the land. You do not argue that a recorded reservation vanished because your title company slept through page 4. What about the collateral? The collateral is the problem. That farm was never clean collateral." Nathaniel looked through the courtroom window. Clara sat beside the lawyer Walter Neff had found for her the night before. She was still wearing the gray coat. Her hands were folded now, not shaking. Not calm, exactly, just held together. When court resumed, Nathaniel stood. His voice had lost its earlier speed. "Your Honor, after review of the recorded 1971 deed, Millstone Valley Bank withdraws its petition to foreclose on the Beiler farm. The bank acknowledges the recorded lineal re-entry reservation and will release its claimed security interest in the real property." Judge Kessler did not look surprised. She looked careful. "Will the bank pursue Mrs. Beiler personally for the unpaid balance?" "No, Your Honor. She is not a signer on the note." "Will the bank assign any claimed debt in a manner that causes collection activity against Mrs. Beiler?" Nathaniel swallowed. "No, Your Honor." "I want the answer complete." "The bank will not pursue Mrs. Beiler personally, directly or indirectly." Only then did the judge turn to Clara. "Mrs. Beiler, this court accepts the withdrawal. The deed will be entered into the record of this proceeding. Based on the bank's statement, the foreclosure petition is dismissed. The farm is not being transferred." Clara did not cry when she heard it. She simply closed her eyes. For 2 months, everyone had spoken around her as if the land were already gone. The judge had just spoken as if it were still hers. After the hearing, Clara walked outside into the air so cold it made her eyes water. Her son Daniel stood near the courthouse steps. He had not come inside because he could not bear to watch his mother lose the farm in public. When he saw her face, he knew. He crossed the sidewalk and said, "Ma?" Clara handed him the envelope. Daniel opened it, looked at the deed, and then at the courthouse doors. "All this time?" "All this time," Clara said. That evening, the farm did not look saved. Nothing dramatic changed. The cows still needed milking. The west gutter still leaked. The calves still bawled when the grain cart passed. But the lane sounded different under Clara's shoes. For the first time since Isaac's funeral, she walked from the house to the barn without counting what might be sold. 2 days later, Terence Morrow drove to the farm in his own truck. He did not bring a bank folder. He brought a hat in his hands. Clara met him on the porch, and for a moment neither of them spoke. Terence was a practical man, not cruel, but he had watched the bank's paperwork move toward her house and had not stopped it. Finally, he said, "Mrs. Beiler, I am sorry." Clara looked past him toward the lane. "Did you know?" "No." "Would it have changed what you did?" Terence did not answer quickly. That was the first honest thing he did. "I hope so," he said, "but I do not know." Clara nodded. That was not forgiveness, but it was a door left unlocked. The bank recovered part of its loss from the title insurer. The machinery note was settled through the estate. Some equipment was sold. The adjoining 40 acres Isaac had tried to add was let go. Clara kept the original farm. But keeping land is not the same as saving it. The clause required active family farming. Without that, the fence in the deed would become only a memory. So Clara called her children to the kitchen table, not the parlor, not the lawyer's office. The kitchen table, where bills had been paid, seeds sorted, and grandchildren fed applesauce from chipped bowls. She placed the 1971 deed in the center and said, "Your grandfather's father did not save this farm so it could become a story in a display case." Daniel looked down. He had wanted the farm, but not the weight of it. His wife was afraid of the hours. His siblings were afraid of unfairness. Clara was afraid of forcing love into duty until both were ruined. The conversation lasted 7 hours. They argued about money. They argued about inheritance. They argued about whether 40 cows could support a family in a world built for 400. By midnight, the decision was not perfect, but it was real. Daniel and his wife would move into the tenant house by spring. Clara would keep a life estate in the farmhouse. The siblings would receive structured payments over time, not a forced sale. The herd would shrink before it grew. The farm would stop chasing scale and return to what it could carry. A new deed was drafted in 2024. This time, everyone read every line. The lineal re-entry reservation remained. A second provision was added, requiring any family successor to maintain agricultural use for at least 10 months of every year. A third required that no mortgage could be signed unless every adult family interest holder received independent legal advice. Clara insisted on that sentence. She had learned that love should protect people not only from strangers, but from the good intentions of their own dead. By the next winter, the farm was smaller, quieter, and steadier. Daniel sold the newest tractor and kept the older one that was paid for. They rented pasture to a neighbor for heifers, a small share of milk for a local creamery that paid more slowly but more fairly. No one got rich. That had never been the promise. The promise was that the land would not be taken by a signature nobody understood. In April, Clara donated a certified copy of the 1971 deed to the County Historical Society. Not the original. The original went back into the roll-top desk. The curator asked if she wanted a plaque with Amos Beiler's name. Clara said yes, but she asked for one sentence beneath it. "He built the fence where no one thought to look." People came to see it because it sounded impossible. A farm saved by a paragraph. A bank stopped by an old clause. A widow, protected by a man she had never met. But Clara never liked when people called it a miracle. A miracle arrives without warning. This had been prepared. prepared by a boy who remembered depression auctions, prepared by a farmer who understood that banks read land as collateral, but families read it as time, prepared by an old attorney with a typewriter, prepared by a county clerk who stamped the deed instead of sending it back, prepared by a desk drawer that stayed dry for half a century. The world had changed around the Beiler farm. Interest rates changed. Milk prices changed. Banks merged. Title companies digitized their searches. Children moved farther from barns. Land became worth more to developers than to the people who kept it alive. But one sentence in one old deed did not change. It waited until the morning it was needed. Years later, Clara would tell her grandchildren where the deed was kept, but not what every word meant. When the oldest asked why, she gave the same answer Amos might have given. Because a thing found at the right time teaches more than a thing explained too early. Then she tapped the roll-top desk. The fence is in here. And for once, everyone understood. The bank had paper. Amos had paper too. But his paper had roots. That was the difference. The fence was not around the farm, inside the deed.